Could you share with us the benefits of self-representation? Because I've enjoyed these benefits and I've been expounding on them on our social group, and I think there's a tremendous amount of fear that the general public have with regards to the law, and we've all been conditioned to think we have to have a lawyer. I've been to the Magistrates Court, the High Court on 3 accounts, and I've enjoyed tremendous sympathies from the judges as a result, and because the defendant rather ignorantly thought that my notice of action that I had to supply to him in an urgent application to the High Court in Johannesburg was a hoax, and he thought it was just an intimidation tactic. He didn't arrive. And what I enjoyed was actually a very personal conversation with the judge, who expressed tremendous sympathies towards me. So I'd really like you to share with us.
Certainly.
That's
So, without you all knowing it, is that there exists a duty on a presiding officer to come to the aid or assistance of a layperson. There is a duty, okay, on a presiding officer to come to the aid or assistance of a layperson. Even in the midst of a trial, if they see you battling with grappling or to understand the questions or the terminology or whatever that was put forward or the legalities, they have a duty to come to your aid in those proceedings as well, all right? So there is such a duty, which then obviously assists you as a layperson in that litigation process. So that is definitely one of the benefits. Secondly, another benefit is, of course, because you are a layperson, they understand that you don't understand the technicalities of the legal or the legalese. So they do give you the benefit of a doubt, I suppose, in terms of instances where you don't comply with certain procedural steps, certain time frames. You understand? So they do accommodate you, or rather give you the benefit of the doubt under those circumstances. So they won't deny you the access to the justice simply because you have filed your pleadings out of time because you didn't know you were supposed to file it within 10 days. Okay, provided you obviously stipulate in there that you've done it on your own, you unrepresented, you can't afford legal representation, this came to your knowledge only on this date. If you had known about it earlier, you would have done so. So you need to obviously assert yourself. You need to make the right statements and give the right comments, but definitely you can expect assistance or an aid by, the presiding officers in these courts, high courts, magistrates courts, regional courts, and tribunals. So definitely there is. I think one of the key things, I suppose, that I can say, and which I can pick up from Nikki's demeanor and what she shared so far, is that she informs herself. Obtaining the information, getting the right guidance. Fortunately we're in the day of information, right? And an age of information. So everything is essentially available at the tap of a button, okay, on your smartphone or on your laptop or on your iPad. So there's a lot of information. It's accessible to everyone. So I think the key thing is that if you are going to pursue your own litigation, just make sure that you make use of these resources. And you'll also find that there are a lot of websites where attorneys do brief summaries, where they give you the bullet points of the things that you should put in, the things that you shouldn't forget, that helps you to understand how to fill out a form, okay? I mean, there's even resources on the government websites where you are given guidance in a little bit of a short package or brochure where they set out, and I can show you an example, where they set out exactly how you go about filling out a form, what is it that you must fill in that form, what does it mean when they ask you this thing. So it's there to help you because they understand that access to justice isn't easy, right? And it's expensive, okay? So in order to equip people and afford them and enable them to have access to justice, they make these resources available online. Now, I can't really tell you what are the links. Maybe I can try and put a little bit of a summary together and send it to Penny, and Penny can share with you, but there definitely is a wealth of resources out there to help you if you litigate on your own. So, for example, look at this. I thought this was so cute, and I had to print you guys a copy. So this is about protection orders, okay? Now, this document was available on a government website, okay? So justice.gov.za, right? Now, this one is about specifically domestic violence, okay? So it says a simplified guide to the Domestic Violence Act. So it explains it in such minute, or rather, let's say it, simplified terms that you don't even need somebody to explain it to you again. It's there. They even define what constitutes domestic violence. They even define what constitutes emotional abuse. Okay, they give you examples. They circumscribe the terms. Okay, in this particular document. So, and it even tells you what you should bear in mind when you fill in your affidavit, okay? What you must make sure that you fill in so that you can enable the presiding officer to understand what you're talking about, to understand what is the nature of the abuse that you are being subjected to, and to understand what outcome you want, what remedy do you want the judge or the magistrate to give you, rather, in terms of that protection order, okay? Like there was something that I picked up earlier on when you worried about whether somebody that you're living together and you don't want that person to come to your house anymore. You can actually, and it explains it in here, in your protection order application, you can say that we have this communal home at address so-and-so, and the order I want is that the court precludes this person from coming to this house, coming to our joint household where we're living. So even if you live together, if the nature of the person's presence presents harm, presents danger, presents a threat, creates or establishes the abuse, you can apply to court to order that that person doesn't come. And they will then have to find an alternative place to stay in the interim. Okay? There was a hand there, and there was a hand. Yes.
With regards to this domestic abuse, do they consider coercive control as being domestic violence, as in emotional abuse, gaslighting?
I'm going to read it for you. Let me read it for you guys. I absolutely love this document. I thought it was brilliantly put together. So, so that's the domestic relationship. Yeah, here we go. You are experiencing domestic violence if a person with whom you are in a domestic relationship does one or more of these things to you, right? And then they unpack it, okay? See, there's the heading. I don't know if you can all see it. And they unpack it. Then they say the first one, it's physical abuse, okay? We all know that. What is physical abuse? Okay, let's skip over that one. Sexual abuse, I think we can all understand what that means. Let's skip over that one to get to Penny's question. Emotional abuse. Psychological abuse, verbal abuse. So let's zone in on those quickly. Emotional abuse. When the person harms you emotionally, like saying things on purpose to hurt your feelings, shouting at you, and calling you bad names. He could be doing or saying things that make you feel bad about yourself or scared, like threatening to take your child away from you if you divorce him, or threatening to hurt you physically. That's emotional abuse. It's defined justice.gov.za. This is South African law, okay? We'll get there. We'll get there. Psychological abuse, when the person harms you psychologically, like saying or doing things on purpose to affect your mental or psychological state of mind. Right? So remember, these resources are given on training to officials of the courts. Right? So these things, they need to know these things, okay? And hopefully everybody will really start embracing this and start understanding these things. But we're getting there. To Nikki's question earlier on, you know, the judges and the court officials and magistrates, are they sensitive to narcissism? Right? So these are all things that narcissists do, okay? Let's continue. Like doing things on purpose that affects your mental or your psychological state of mind. He could be undermining you or making you feel like you are a worthless and bad person without dignity. So that's all psychological abuse, okay? It's there. It's one for which you can file a protection order. Verbal abuse, when the person harms you verbally, like swearing at you, calling you bad words and names, and shouting at you a lot. Okay, and it says here even, every person, and this is constitutional rights, every person has the right to have her human dignity respected. Dignity is the feeling that you are a human being, and that a human being that has emotions with self-respect or self-esteem. Okay? That's how they define dignity. Right? So if you feel that somebody is affecting your dignity, it can constitute abuse, and you can file a protection order. Then it goes on. Economic abuse. When the person harms you economically or financially, like using money to try and control you or your behavior. For example, she steals your money or belongings, refuses to buy food for the children, to pay the children's school fees, or refuses to give you money for groceries unless you stop seeing your friends. Coercion. Intimidation. When the person threatens to hurt or harm you, your children, your friends, or family if you do not do what he or she wants. Also, if she or she bullies you, scares you, or puts you under pressure to do or not to do something. Psychological, emotional, and verbal abuse can also be considered to be intimidation. Okay. Harassment, when the person watches you or follows you all the time, or sends you unwanted letters, messages you on your phone, or emails you. Also, if the person calls you all the time, even when you asked them to stop calling you. And then there's stalking, damage to property, when the person damages or destroys your belongings on purpose. For example, she or he breaks or spoils your personal things, kitchen things or furniture, or breaking the doors and windows of the place where you stay. Okay? And then when the person comes into the place where you live, which you do not share with that person without your invitation or agreement. Okay, this is now when you're living apart already. You have an issue like that. Any other behavior by the person that is abusive or harmful and has a bad effect on your safety, your health, or your well-being. Okay. So useful document. Does that sort of touch on your question, Penny?
Yes, it does. As someone else in the audience asked, how on earth do you prove this? So are recordings upheld in court? Can you record and then say this is actually what happened?
Yes. Thank you so much. Luckily, I was able to prepare because Penny and I discussed this issue 2 or so weeks ago over the phone, and I shared my sentiments on the issue with her. Now, firstly, let's start with the law, and then we'll deal with the practicalities. So the law is regulated in the Act. It's called the Regulation of Interception of Communications and Provision of Communication-Related Information, Act 2002. All right? Act number 70 of 2002. It's called RICA for short. Now, in terms of this Act, and particularly Section 4, and I'm going to read it for you. This Act says, any person other than a law enforcement officer may intercept any communication if he or she is party to the communication, unless such communication is intercepted by such person for purposes of committing an offense. Do you get that? Let me explain. You are allowed to intercept communication. And interception is recording somebody, recording a conversation. That's interception. As it happens, recording it, videotaping it as it happens. That's interception. Okay? So if you are party to that conversation, if it's an argument between you and your spouse, you can record it in terms of this Act. Yes, ma'am.
Sorry. I did do recordings.
Yes.
My daughter would disclose stuff to me, and then afterwards I would record because no one was believing what she was telling me.
Yes.
And that was held against me.
Yes.
I took it to the social workers, and they said that I was coaching her.
Yes.
She even drew pictures while she was in a facility for like 3 or 4 months.
Yeah.
Foster care, and they held that against me. And it's a very complicated situation, but my daughter's been taken away from me.
Oh, okay.
And
sorry to hear that.
Just before lockdown,
my
ex took my daughter to the Eastern Cape. I haven't seen her for the whole duration of lockdown, and prior to that, she hasn't been with me for 2 years.
Yeah.
I had to pay to see her for an hour a week.
Yeah.
When I was innocently trying to protect her,
Yeah.
and now she's been taken away from me.
Yeah.
How?
Okay. Okay, so it's a very complicated scenario. So that was the law, and I said we're going to deal with the rest, right? I said let's first read what the law says. As much as that's what the law says, that if you are party to the conversation, party to the communication. Now, in this particular instance, is sure.
One more thing. Her curator, she was appointed about a year ago or longer, had a telephonic conversation with a clinical psychologist I saw in the beginning of the case.
Yeah.
And 2.5 years later, she diagnoses me over the phone and says, I've got Munchausen by proxy, and this is why my daughter's been taken away from me. I've been falsely accused. My parents were also implicated. My mom had cancer. She just passed away recently.
My condolences.
And she had to pay 700 Rand for my daughter to come and see her.
Yeah.
It's, you talk about human rights, kids' rights, children's rights.
Yeah.
Where is that in all of this?
Yeah, yeah. You know, because of that scenario, and I thought it might come up, you know what? The best I believe in is resources, right? And one of the best resources that I find is previous case law. We call it precedent, right? So it's always useful when you do research, especially when you handle your own litigation, to go type into your search engine a scenario that you're dealing with, like in your particular instance, okay? And find and type in .caselaw.sa, right? And draw some cases and have a look at them, read through them, because it not only gives you a better understanding of the scenario that you are dealing with, but it also tells you how the courts expect you to handle it, how the court expects you to deal with it, what you can and cannot do. And also it gives you an indication of what the court can potentially find as a conclusion to that particular matter. Now, this particular judgment that I have here is quite a comprehensive one, but I absolutely loved it because I love the way in which the judge unpacked every element. Now, in your instance, it's about the first thing that is important in law when it relates to children and marriages is that it's not about the couple, it's about that child, okay? So the first thing is that it is about the interest of the child. That is priority. So any decision that should be made in the context of the best interest of the child. And it's never in the best interest of the child to grow up without either one of the parents, actually. Unless, of course, that parent presents serious harm to that child. But the basic principle is that a court should make a determination that enables the parties to have access to that child, to build a relationship with that child, okay? And that's the first priority. I'm going to give you this copy so that you can have a read at it. But anyway, to take your scenario a little bit further, you know, it is unfortunate reality that sometimes your decision is based on a throw of a dice. Who ends up being your judge or who ends up being your magistrate? It's really sad, and what their perspectives are, you know, what view they hold of life and of issues. So as much as the law says something, there are the instances, you know, and I'm conflicted to even admit and acknowledge that, but there are instances that where there is a miscarriage of justice by presiding officers and even the police officers who are enforcers of the law. And sometimes you end up with a decision that you cannot even explain. You cannot even justify it. It is so in contrast to the evidence that was before the judge or the magistrate. But in those instances, your only recourse, as I said earlier on, is to then either escalate it to a level where you can file a complaint, and if it's something that can be subject to an appeal, you should then obviously file an appeal. And as far as access to your child is concerned, there is also the avenue of bringing an urgent application to have access to the child. I don't know if I brought those forms, I think I left it, but there is an application that you can fill in yourself at the regional court, or the magistrate's court rather, where you can ask for access to your child in the event of an abduction. This is regulated by the Hague Convention, to which we are a signatory. And in terms of that Hague convention, there are certain regulations that enables you as a parent to get access to your child in the event your child has been removed from the geographical area in which you stay without your consent. Okay.
Okay.
Yeah.
Thank you.
Okay, pleasure. Yes, ma'am.
Hi, I just actually have just 2 questions. I had a maintenance. Sorry. Hi, I have a maintenance appearance on the 9th of September that has passed. And what happened was my ex, actually still my husband, he applied for maintenance reduction. And it had, and then he applied for it, but it got postponed to September. But we actually have an interim settlement agreement that stipulates that he pays an X amount, and he pays medical aid and he, towards medical aid and school fees, etc.
Was that settlement agreement made an order of the court?
Yes.
Then he's in contempt of court. You can bring an application, and he can even be arrested.
So what? Okay. So this is what happened now. On the 9th of September, I came to the court date without a lawyer.
Okay.
And I didn't hear my name being called. He actually spoke to somebody in the maintenance office, and he excused himself. He said he had an emergency. Now I didn't see that, so I was waiting for him to see him for me to go in. So I knew that it was my turn. I waited there till 11 o'clock, and then next thing I asked what's going on to the maintenance officer. They said, no, you must come tomorrow. So I said, how come must I come tomorrow? They said, no, it was rolled over because he excused himself. So on the 10th I couldn't make it. I was struggling because I had no one to watch my children, and it was short notice. So I tried to phone everybody. I even emailed the maintenance officer, everything, and then I even started calling my lawyer to try and help me. No one could help me. So I got to the court at about 11 o'clock, and then they told me it was ruled because I was seen as absent. So I said I'm not happy with it because I was here yesterday, and I did explain to everybody that I had a struggle to get here today, and I wasn't absconding or anything. So they said to me I have to appeal at the High Court. So now I've asked my new lawyer to another lawyer to appeal it. So I'm just going to ask you, is that interim settlement, isn't that still going to hold against what he did? Because now, as it's effective September now, end of September, I was getting the reduced amount because they ruled everything in his favor.
100%. So the settlement agreement that dealt with maintenance, and the maintenance in the settlement agreement was at a certain amount. So when you have a settlement agreement that provides maintenance of 1,000 rand per month, for example, per child, and your spouse then goes to the maintenance court subsequent to that divorce having been granted and goes to the specialist court that deals with maintenance matters, whatever decision comes out of that court supersedes the decision that was made in the settlement agreement. So if the settlement agreement was 1,000 rand, for example, and you've made an application to the maintenance court to have that increased offer will then prevail. All right? So in your scenario, if an order has now been granted that the maintenance that was initially agreed to in the settlement agreement has now subsequently through court order been reduced, then that prevails. And the only way for you to now increase that maintenance order is either to wait for, I think it's 3 months. There is a certain period of time by which you can wait to reapply again for an increase in maintenance. Because you can apply for an increase in maintenance at some point in time, but there is a time frame by which you have to wait before you can bring another application. I'm not sure what exactly that time frame is. It might be cheaper to wait for that period to lapse, bring a new application to increase your maintenance, than to actually go for an appeal out of the High Court. So consider the possibility of doing that, okay? Because the High Court, an appeal is costly, it takes time. You're going to have to wait for that period anyway before a final decision is made. So you might as well wait that period and bring another application for maintenance. Yes, ma'am.
Thank you, Ronelda. I'm aware that we're running over time.
Yeah,
is
what
it
time
okay
is it?
to just field one more question?
Yes.
We'll close. Thanks.
Okay, sure.
Thank you so much, Ronelda. So just a couple of questions. You spoke about the interception of the conversation that you are party to. So you cannot intercept a conversation that you're not party to. If he's talking to someone, his girlfriend or whatever, you cannot record
that. That will be considered unlawful. That would be considered. You can only do that through an application in the court. It's dealt with in this act, I think under section 16 or something, but you can only do that through an order from the court. So you basically have to bring an application, and the court must issue a directive that conversation then be intercepted through the telecommunications that person is on. Whether it be, what do we call it? MTN or Vodacom or Telkom or whatever. Okay, so it can be done, but by court order, or of course also by a enforcement officer who believes that the interception is going to prevent a crime from taking place or to locate somebody that's missing.
Okay, thank you so much. And then maybe just one last one. In terms of lodging, if you're both in a situation where you want to go ahead with the divorce.
Yes.
So if it's me, for example, is it better that I do it first? Are there advantages to who files the divorce application first?
No, not really. Not really. And even if you are the defendant, because obviously for me, an advantage is that I want my divorce finalized as soon as possible, right? Whether you are the defendant or whether you are the plaintiff, either one of the two can push the matter to finality sooner, because either one of the two can apply for a trial date, by the way. You don't just have to wait for the plaintiff to go and index and paginate the court file. If you're the defendant and the plaintiff drags their feet, you can go index and paginate the court file. You can initiate pre-trial proceedings. Write a letter to the opposing attorney if they have attorney and you are unrepresented. You can write a letter and invite them. Send an email and invite them to a pre-trial meeting, right? And apply to the court for a pre-trial meeting, or apply to the court for a directive for a pre-trial meeting. So whether you are the plaintiff or the defendant, you can also ensure that the matter gets finalized sooner rather than later by ensuring that those processes are complied with. And if somebody drags their feet in the litigation, let's say, for example, somebody's supposed to file their plea. Okay, let's say you're the plaintiff. Somebody's supposed to file their plea within that time frame and they don't, and you are unrepresented. You go to the court and you ask for a notice of bar. Okay, the notice of bar, they draft you a template, you sign it, you serve it, and they then given 5 days to file that plea. And if they then don't file that plea, you go back to court and set the matter down or do the next step. Okay, so you can really run the process. Okay. Thank you. Yes, Ivy.
Yeah, it's a bit out of the borders of South Africa. So both my husband and I are not South African.
Yes.
And in 2017, he abandoned the home and left.
Yeah.
But was the primary caregiver in terms of financial.
Okay.
There's been economic abuse. So earlier in the year, I had tried to go to Pro Bono and the Winslow Clinic just to ask, because for me, I wanted closure. Like, if there's no relationship, can I now start divorce proceedings?
Yeah.
And I just want clarity, because at the time it was still at the end of Jan, so there was no lawyers then. So it was a final year student, and I said, he asked me about how would they be able to present the summons, and he said, is it possible that they can still email and the read receipt would act as, or is it no, we have to both physically be in the same space.
Where was the marriage solemnized?
In Kenya, but we've been here for we've been out of home for 20 years.
Okay.
Yeah.
So, but you want to institute divorce proceedings here in South Africa?
Yes. So we've been living here for the last year.
But the marriage was solemnized in Kenya.
Yes.
You're going to have to initiate, if I might be wrong, but you might have to initiate divorce proceedings out of Kenya.
Okay.
Because it was solemnized there. So it's solemnized in a different jurisdiction.
Yes.
So there is recognition of foreign marriages.
Sorry.
Okay.
So if you're inside the Kenyan embassy, you're inside the country, and they have a legal officer. I was involved with one case.
Yeah.
So the embassy building constitutes part of Kenya. You call a legal officer inside that building, and they can start proceedings for you. This happened
out of the Kenyan embassy. Okay.
So
Ma'am, you
the
also...
is considered part of that country.
Yes, that's right, the embassy.
No, I agree with Nigel. I just wanted to add on, we are Zimbabweans, but with residency here, so we are getting divorced in this country, because there's something about domicile. So if you domiciled here and we've got permanent residents and all of that, we've just started proceedings.
100%. Okay. Thank you. Thank you so much.
I think we're going to have to wrap it up there.
Yes.
Thank you all for your questions. And thank you so much, Ronelda. Wow.
Okay. Thank you.